This is the third study session of ACT 219 Commercial Law. We are going to continue our discussion on law of contracts. On completion of this study, you should be able to explain clearly the meaning of consideration. You should be able to explain intention to create a legal relation, and you should be able to list the category of people that cannot make contracts. Consideration can simply be described as the price paid by promisee for the promisor's promise. When somebody promises you something in exchange for value, such promise is enforceable as a contract. The problem, however, has been that of determining what will be of value in the eyes of the law to qualify such promise as a consideration. Lush in Curry vs. Mesa case offered the opinion that a valuable consideration in the eyes of the law may consist either in some rights, interest, profit, or benefit accruing to one party, or some forbearance, loss, or responsibility suffered or undertaken by the other party. We can say, therefore, promises not given for value are merely gratuitous and are invalid as they are just nudum pectum, that is, gratuitous promise. There are certain basic rules or principles that govern consideration, and these are: 1. Consideration must move from the promisee. This means that it is only a person who provides consideration in a contract that can bring an action to enforce it. The promisee must show that consideration was provided by him. Another one is consideration may be executed but must not be passed. If one party voluntarily perform an act and the other party then make a promise, the consideration for the promise is said to be in the past. The rule is that past consideration is no consideration, so it is not valid and cannot be used to sue on a contract. For example, when A gives B a lift home on his car, on arrival B promised to give A 500 naira towards petrol price. A cannot enforce this promise as consideration because the lift he gave B is something of the past. The third one is that consideration must be sufficient. Where consideration is recognized by the law as having some value, it is described as real or sufficient consideration. And the last one is consideration need not be adequate. Like I said before, provided consideration has some value, the court will not investigate its adequacy. Where consideration is recognized by the law as having some value, it is described as real or sufficient consideration. The court will not investigate the contract to see if the parties have got equal value. The last element of contract is intention to create legal relation. From our previous study session, we have mentioned some elements of contract to be offer, acceptance, and the last one is intention to create legal relation. In addition to mutual exchange of promise and the presence of consideration, the parties must have the necessary intention to call for the assistance of court should the agreement be dishonored. This necessary intention to be bound by agreement is known as intention to create legal relation. In commercial contracts, the court readily presumes the said intention, while in cases of social and domestic engagements, the intention to create legal relation is deemed to be lacking. That is why father cannot sue son because he did not do what he promised or agreed on. Likewise, husband cannot sue wife. Capacity to contract. Capacity to contract means the legal competence of a person to enter into a valid contract. Usually, the capacity to contract refers to the capacity to enter into a legal agreement and the competence to perform some acts. The basic element to enter into a valid contract is that he must have a sound mind. The law treats some category of people differently when it comes to capacity to contract. It grants them protection in that they enjoy special status in contractual transactions because they are vulnerable to being exploited or defrauded in making of agreements. This category of people are infants, illiterates, lunatic, drunkards, among many others. In common law, an infant is a person under 21 years of age. The general rule of common law is that contracts made by an infant are voidable at his option, except as relates to contract for necessaries and beneficial contract of service, which are regarded as binding on the infant. Contracts for necessaries include food, clothing. It is, however, for contract of necessary to be binding on the infant, they must not contain harsh and onerous terms. The next one we'll be talking about is capacity of an illiterate to enter into contracts. The law does not afford an illiterate person any privilege or protection as against the other party, provided that the contract is oral. On the other hand, if the contract is written, whether under seal or not, then different rules apply as the law offers the illiterate some protection. This will be explained further in the next study session. This is the end of this study, and I hope you have enjoyed this discussion. You can read more from your study pack in order to complement your knowledge about the subject discussed in this video. Thank you for listening. See you in the next class.